Okay. Good morning and welcome, everyone. I'm Zanae Dames, the Marketing Events Manager at Digital, and I'm pleased to welcome you to our first webinar after our summer break. Today's topic, navigating copyright and ownership, AI as an author. As myself and much of the Digital team are based in Vancouver, British Columbia, we respectfully acknowledge that we work, learn, and live on the traditional ancestral territory of the Musqueam, Squamish, and Tsleil-Waututh peoples. Please note that this webinar is being recorded and will be shared with our audiences in the coming week. If at any point during the session you have a question, please type it into the chat and we'll address them at the end during the Q&A portion. That's it from me, and I'll be handing it over to Jen, our Director of Intellectual Property, to get this webinar started. Thanks, Jen.
Thanks so much, Zanae, and bonjour everyone and welcome. It's wonderful to have attendees joining in from across the country for this month's webinar. And whether you're new or a returning participant to Digital's IP series, we're thrilled that you can join us in for this Thought Leadership Power Hour. Next slide, please. Perfect, thank you. Advancements in AI technology have brought content ownership to the forefront, and recent court decisions in Japan, Germany, the UK, and the US have highlighted critical IP issues for both organizations and creators, and how current IP rights are being tested by the rise of AI-generated content, sparking questions such as, who owns the work when it has been generated by AI? Can an AI system assign or license its IP rights? How can organizations responsibly use generative AI given IP considerations? Over these next 60 minutes, we'll explore the Government of Canada's recent consultations on the authorship of AI-generated works and potential amendments to the Copyright Act, cases on the authorship of AI-generated works, patent protection considerations, and practices to guide your organization around the responsible use of Gen AI tools for content creation, as well as part of the invention process, with a Q&A portion to close out. Next slide, please. Fundamental to the global innovation clusters is collaborative innovation, setting the framework for projects that address cross-industry challenges while creating technology products and services that can scale across industries and ultimately across the world. Digital's IP strategy supports the development, ownership, and retention of Canadian IP through numerous vehicles, and informational sessions with thought leaders like we've today are one example of that. Next slide, please. I have the pleasure of introducing today's speakers. Please join me in welcoming to the panel Maya Medeiros and Elizabeth Williams. Maya is partner at Norton Rose Fulbright, Vancouver, and an intellectual property lawyer, patent agent, and trademark agent. She has extensive experience in IP and complex technologies, including AI, and advises a wide range of companies on IP strategy and delivers tailored IP policies and training programs, ethical guidelines, and collaboration agreements. She is a key contributor to Inside Tech Law on the ethical and legal implications of artificial intelligence, and an adjunct professor at York University, where she teaches on the commercialization of intellectual property. And Elizabeth, managing partner at Norton Rose Fulbright, Calgary, and has broad experience in both business and intellectual property law. She has extensive experience in major and multi-jurisdictional M&A transactions, complex licensing and IP commercialization matters, and portfolio monetization, and advises across a variety of industry sectors, including consumer goods, energy, manufacturing, and technology. She is a member of the firm's Canadian and Global Management Committees, and most recently recognized in the 2025 edition of the Best Lawyers in Canada as Intellectual Property Law Lawyer of the Year. And with that, I hand it over to you, Maya and Elizabeth.
Thank you, Jen, for that warm introduction, and to the whole Digital team for having Elizabeth and I today to speak about a topic we're very interested in. And let me just share my screen. So as Jen intro, we're going to discuss AI as author, looking at AI-generated works. And so we wanted to pause and just kind of look at some of the different types of works. And from a copyright perspective, the Canadian Copyright Act looks at or refers to original literary works, dramatic works, musical works, artistic works. And we want to today explore the open question of whether AI-generated content can be protected by the various forms of intellectual property rights, focusing primarily on copyright. So I put a few examples of I put an example of literary work, a poem that Copilot generated, Whispers of the Breeze, Leaves Dance in the Golden Light, Autumn's Gentle Kiss. I thought that was nice. Another example of a literary work I included was computer code. So you can see that literary works are quite broadly defined or considered. And this snippet of code that was automatically generated by an AI tool also automatically generates musical scores, which is another example work. And so you can see the Copyright Act addresses these different works, and you can see how important and valuable these works are to our societies and businesses. And so Elizabeth's going to look a little bit closely at AI-generated artistic works. So I'll turn it over to her.
Thanks, Maya. And thanks everyone for joining today. So at a very high level, I appreciate that many of you may be familiar with what's protected by copyright. But as Maya just alluded to, in Canada, copyright is governed by the Copyright Act, and copyright subsists in every original literary, dramatic, musical, and artistic work. So here on your screen, you'll see a couple of examples of artistic works that were created through generative AI. And generally, as far as copyright is concerned in Canada, protection arises automatically upon creation of a work anywhere in the world, provided that the author, which we're going to focus on today, I really want you to think about who is the author, is, you know, an individual or a citizen of Canada or a treaty country. And as you may be familiar, copyright lasts in Canada during the author's lifetime and 70 years following the author's death. So the author in Canada is the owner of copyright. And there's two sort of exceptions here. And that's if you have an employee who creates a work in the course of their employment, although they're still be listed as author in Canada, and where a work is assigned. So copyright, as you may know, may be sold or assigned in whole or in part. And any assignment of copyright must be signed by the owner, and it must be in writing. So one other point I just want to highlight, because we're going to get into copyright registration momentarily, but copyright can be registered with the Canadian Intellectual Property Office here in Canada. A certificate of registration is evidence that copyright subsists and that the person or entity registered is the owner of that copyright. In Canada, it works a little bit differently than the United States. For example, when you're moving to file for registration of copyright, there isn't any sort of substantive review of that particular work. So all that really is required in Canada for an application would be the title, the category. So as Maya alluded to, is it a literary, musical, artistic, dramatic, or compilation? The publication date, the owner, the author, and a declaration that the applicant is the author, plus a small fee if you submit that online. No sample is actually required for the purposes of registration in Canada. And that's important to remember as we move through this process, and sort of a big difference between Canada and the US and some other offices around the world. So here we have a couple of examples of artistic works. You may be familiar with the computer scientist, Dr. Stephen Thaler. And Dr. Thaler applied in 2018, and in particular in the US, for copyright covering a recent entrance to Paradise. And that's the piece of art that you will see here. It's a piece of visual art. And he has said his AI system, Davis, created this without any human input. The US Copyright Office rejected this application in 2022 and said that the creative works must have a human author to be copyrightable. So of course, you will probably also be familiar with the fact that computer assisted or computer aided works can be protected by copyright. However, authorities around the world have been sure and made this distinction between computer assisted and computer generated works. And we're going to go into more detail about sort of those differences in a minute. But this distinction is supported by case law really from around the world and case law from Canada. And Maya is also going to touch on Germany and Japan. And we're going to touch on, obviously, the US in a couple of minutes as well. The United States Copyright Office has also issued guidance on the protection of generative AI. and in particular that content, and holding that the content produced without sufficient human involvement is ineligible for copyright protection. And Maya is also going to speak later to the similar principles that have been applied as far as generative AI inventions have largely been ineligible for protection under patent laws, as inventors must also be human beings. We also have another example here. You may have heard about this Rembrandt project that was through actually ING and the Walter Thompson Agency in Amsterdam, bringing in other technology partners, including Microsoft. They brought a team of data scientists together, engineers, art historians, to analyze Rembrandt's painting technique, style, and subject matter, and transferred this knowledge into software that could generate new work. And that's what you'll see here. This is a new work using the latest in 3D printing technology. Although no copyright application was ever filed, this is just another example of generative AI artistic works. So we'll just move to the next slide here. And here, this is more relevant in Canada. So this is a piece of art called Surrealist, and CIPO issued copyright registration in December of 2021 for an AI-generated image inspired by Starry Night. This two-dimensional artwork was produced by providing a generative AI tool called Raghav with a base image. We'll see in the next slide in a minute, Mr. Sani, who worked with Raghav here, had an original photograph and a style image of Vincent van Gogh's The Starry Night, and an undisclosed numerical value for the style and transfer and strength. And then Raghav then generated the Surrealist work using that generative AI system. In just recently, a couple of months ago, in July 2024, the Canadian Internet Policy and Public Interest Clinic, which we're going to call CIPIC, filed an application in the federal court. And what they filed was an application to expunge or amend this copyright registration, which named the artificial intelligence as co-author. Here in this slide, you'll see that, if we just go to the one where we see the inputs, Maya. There's the inputs there for the creation of Surrealist, which was Mr. Sani's original photograph as the base image and Vincent van Gogh's The Starry Night. And in its application, if we go to the next slide, CIPIC has challenged CIPO's automated copyright registration process. So as I mentioned at the outset, the copyright registration process in Canada and the US is a little bit different, where there isn't, the same level of sort of a substantive examination and of the actual work that is being moved to register. So unlike other jurisdictions, and in particular the US, they don't conduct a substantive examination of the application here in Canada. And what CIPIC has claimed is that CIPO is derogating from its obligations to administer copyright in a fair and balanced manner under the Copyright Act. So if we move to the next slide, CIPIC's application challenges the copyright registration for Surrealist and seeks expungement of the copyright, or in the alternative, to remove Raghav as a co-author. And so CIPIC makes two main arguments. One, that Surrealist does not meet the originality requirement for copyright. As we sort of mentioned at the outset, that is a requirement. It must be an original literary, artistic, dramatic work. And two, that an AI system cannot be an author under the Copyright Act. On the originality argument, CIPIC advances that Mr. Sani merely provides three inputs into Raghav: a base image, a style image, and a value for how strong to apply the style image to the base image. And CIPO argues that merely providing these inputs was a mechanical process, and no human skill or judgment was used to produce Surrealist, and that the author, in this case, in the Copyright Act, only refers to a natural person or a human being, and that an AI system cannot exercise the common intent required for joint authorship. SIPC also refers to the denial of the copyright registrations of this piece of art, Surrealist, in other countries, including in the US. So it's been a long-standing tenet of copyright law that an original work must be created by an author. And as we spoke about just a few minutes ago, a person can be an author where a computer-based tool is used to assist in creating the work, as long as the person controlling the computer is seen as directing or fashioning the material form of the work. But if a person does not contribute sufficient independent intellectual effort to satisfy the Canadian Copyright Act's requirement for originality, the individual using the computer would likely not be considered its author. And this is the basis for the long understood distinction between computer assisted and computer generated works. So if we move to the next slide here, yep, go back one, sorry, Maya. Just to highlight what the US Copyright Board has said about Surrealist. They denied this registration and then reaffirmed on appeal its refusal that an AI system cannot be authors for the purpose of copyright in the US. What's interesting, however, in its decision is that the US Copyright Board left the door open for copyright registration of a work authored by a human with assistance of AI, but concluded that Mr. Sani's input was insufficient to rise to the level of human authorship. And the board acknowledged that Mr. Sani conceived of the idea of Surrealist, but found that Raghav was actually the author of the expression of the idea. As we mentioned, copyright does not protect the idea, but rather the expression of the idea. So in refusing the copyright registration, the board in the US held that Mr. Sani exerted insufficient control over Raghav's creation of the work. In the US, interestingly, there have been several decisions, unlike in Canada, where this is just sort of a new issue that we are considering here in Canada. There's been several decisions from the Copyright Office refusing to recognize copyrights for computer-generated works, but allowing copyright as long as the AI-generated portions were disclaimed. So another decision was the US Copyright Office decision in 2023 with respect to the AI image generator Midjourney. And there was users of this Midjourney, and they used it to create images for the purposes of a comic book. And they used extensive text prompts and things of that nature to create these images. But the Copyright Board in that case also denied the registration over the entirety of the comic book, and specifically the images created by Midjourney. However, the author in that case was permitted to register copyright for those aspects that she had authored. So for example, the text and the selection and arrangement of those images and the text. And so the US Copyright Office confirmed that copyright is limited to human authors and concluded that Midjourney, again, was the author of the images. And so the Copyright Office in that case likened the use of Midjourney to commissioning an artist to create an image and focused on the fact that human users did not have sufficient control over the generated images. And specifically, there was no way for human users to predict what specific image would result from a particular prompt. And so these decisions very clearly show in the US that control over the output of an AI is considered when establishing that human authorship. If we move to the next slide, this is just one other example that we're continuing to watch. CIPO has issued, again, another copyright registration for AI-generated artwork just recently in April of 2024. But in this case, it has a human author listed, who's actually a lawyer, Hugh Stevens. But you'll see here in the title, Sunset Serenity, it's being an image and poem about sunset in Ontario Lake, created entirely by an AI program, DAL-E2 and the ChatGPT, on the basis of prompts demonstrating minimal skill and judgment on the part of human claiming copyright. So this will be another interesting one to watch. I expect that CIPC is also watching this carefully, but likely to raise this after they've moved through with the SURYAST application. So now I'm going to give it back to Maya, who's going to talk about some global perspectives with AI generated works and copyright.
Thank you, Elizabeth. That was a really helpful summary of the Canadian position. And just referring back to that comment in the title, referred to skill and judgment. And as Elizabeth referred to, in Canada, the test is copyright will protect an original work, and an original work is one that requires skill and judgment, human skill and judgment. It referred to minimal skill and judgment, and minimal skill and judgment may be sufficient. And in Canada, we have recognized computer-generated work. It's just, if it's solely generated by a computer is where the issue sort of lies in the discussion earlier. For example, Canada has recognized copyright in seismic data. There's a series of cases out of Alberta, a trial court case, as well as an appellate court case relating to seismic data. And they looked at human skill and judgment on for setting parameters of sensors, and the sensors automatically created that seismic data, and the court recognized copyright in that raw sensor data as well. So that's an interesting case to keep in mind when we're looking at AI generated works as well. And as Elizabeth referred to, these issues are coming up in other countries. The United States has looked at this in a few different contexts, and including that first image we saw with Dabus, the Dr. Toller's AI machine, and a recent entrance into Paradise. The courts in the United States upheld the denial of the US Copyright Review Board of that registration. So they said, no, there's no copyright because there isn't that human author. And so there, in the United States, at least, we're seeing that line of reasoning saying AI systems cannot be authors for the purpose of copyright in the United States. One issue that, we're exploring in the cases, or exploring more, and the copyright offices are exploring, what about work that's authored with the assistance of AI? And I think if you can point to, at least under the Canadian test, you can point to human skill and judgment or human creativity, even though creativity isn't the test in Canada, if you can highlight that, it will generally support skill and judgment. So keeping a human in the loop and figuring out what that human involvement is and assessing that will be helpful. But it remains to be seen, and it really is a fact-dependent analysis in copyright more generally. So you want to be mindful of that, as opposed to just taking away, one tagline from a case and applying that more generally. Copyright is very fact-specific, and that's why it can be difficult and a lot of uncertainty for an individual case. But looking at that human assistance will be very important. The US Copyright Office is also doing a deep dive into all of the issues surrounded by AI and AI generating works, and just some of the issues around the use of AI for processing work as well. And we'll talk about some of those issues a little bit later. But one I wanted to highlight, in just July of this year, the US Copyright Office published part 1 of their copyright and AI report series. And the first one looks at digital replicas. And so this is a very interesting space because it has an overlap with personality rights. The way that they're defining digital replicas are those, like if I took an image of Elizabeth and morphed it somehow using an AI tool so that it wasn't actually her really in that image, that would be a digital replica. So that could be an image-based, it could be a video-based replica, it could be a voice-based replica, or maybe a text to a certain degree. I find the voice one particularly troubling because I think an image may have an indicia that it might be fraudulent or not actually the proper image or video, but voice can be a bit trickier, I think, because it's hard to really know if recognize that person by their voice. I think you would in your small group, but maybe more generally it might be difficult. And so that digital replica report dives deep into those issues. And so we've included a link there and we can follow up with some resources, but that's just part one. So look out for the other parts in that Copyright Office review. So that's in the United States. We're seeing more cases there, and generally that notion that AI systems cannot be authors, you really need to look at the human author involvement. Japan is also considering this issue. The Beijing Internet Court recognized copyright protection for AI generated content, but based on the element of originality, and again, back to human oversight. So I think that's a real takeaway. If anybody is looking to claim copyright or have copyright protection apply to a work generated by an AI system, is really keeping a human in the loop, providing inputs. Prompt engineering, we know, is a whole area of science now, and so making that known or having that human input as much as you can and documenting that is really important if you're hoping to claim ownership of that AI or protection in that AI generated work. We also had out of Japan last year, the National Council discussed the Copyright Act in relation to AI. And again, referring back to a human user of an AI generated work can be the author. So it's the human, again, not naming the AI system as author, but the human is named as author if they have that creative intention and make a creative contribution. So they're looking at creativity in Japan. In Canada, the test isn't creativity, as I mentioned, it's originality and human skill and judgment. But again, it's hard. It might be a semantic game, but just looking at human input and human providing that contribution and looking at that. I also want to refer to another issue that's coming out of Japan, and we'll discuss it a little bit more in the Canadian context, is a Japanese copyright article 30-4 permits use of work by AI systems for testing technology or data analysis or computer data processing. So here is where it says, look, in Canada, using a work without authorization may be an infringement of that copyright owner's work. But in Japan, they permit use of works for these testing or data processing or analysis purposes. So here they're carving out that ability to use, or at least give a little bit more certainty there. So as I mentioned, Elizabeth and I will dive into that a little bit more deeper and broader later on, but just wanted to refer to that coming out of Japan. Of course, these issues are also being considered in Europe. I've highlighted the UK. The UK Copyright Designs and Patent Act, they recognize computer-generated work. And so this isn't, again, offside with the Canadian position. As I mentioned, there's a series of cases that say seismic data is protected by copyright because human skill and judgment was involved in setting the sensor parameters. And so that raw data is a computer-generated work, but a human was involved. And so the UK also recognizes computer-generated works. And we've included a definition as a work created by a computer in circumstances such that there is no human author of the work. So again, this is where the UK position is just a little bit different than in Canada, where we said we had human skill and judgment involved in that computer-generated work. But then again, in the UK, the author is the person who made the arrangements necessary for the creation of the work. So there still needs to be a human. It can't be completely autonomous. There needs to be some human or the person that made those arrangements necessary. And they've held a government consultation similar to Canada on AI and IP, and they say, look, we're not going to change the law right now. So they're leaving that position, that section and computer generated work as is. And they're also considering a text and data mining exception. As I mentioned, in Japan, there's a version of that. And so this is a live issue in the UK as well. In Germany, we come in and see where the Copyright Act says that the work must be the result of a human author's own intellectual creation. So again, looking at that human's creation and their intellectual, contribution to that work. The creation must result from that person, from their thought, from their creative endeavors, and human intelligence is required. So really looking at that human involvement, and that originates from the idea that copyright law is based on works created by a human author and have a strong link, and at least in Germany and other European countries, to those authors' personality rights. And it's not uncommon that we would see differences in different countries. Copyright law, there is no such international copyright law that applies around the world. And so you really need to pause and look at each country. And we're just highlighting some of the nuances, but just because you can do it in Germany or can't do it in Germany doesn't mean that same would apply in different countries around the world. So we just want to highlight that for everybody. And that's similar for patent law as well as trademark law as well. So you can just see that we're already seeing some similarities globally, but there are many differences as well. And so we're just going to pause now and kind of look at general other copyright issues around AI systems, in addition to the authorship issue that we're exploring. In the copyright world in Canada, you have the right to reproduce the work, distribute the work, modify the work, to create derivative works and what have you. Those are the owner's rights. And an author under Canadian copyright law also has another set of rights called moral rights. And those are tied to the author. And what those moral rights generally mean is the right to be attributed with your work. So if Elizabeth drew something for me and she didn't waive her moral rights, then we'd have to say by Elizabeth at the bottom of that drawing for me. And then another moral right would be the right of integrity of the work. And this one is a little bit broader and hard to understand what the right to integrity means. Generally, I couldn't change that work, that drawing that Elizabeth gave me without really checking with her. If I added something that, she didn't agree with, that could, infringe or impact her integrity of the work. And so generally I shouldn't make changes to the work or do something without making sure Elizabeth was okay with that. In Canada, as Elizabeth mentioned, you can assign copyright. So the author is the first owner, and then they can assign it to either their employer, for example, by virtue of their employment agreement, or any third party, or two businesses can assign copyright or license it. But the author cannot assign its moral rights in Canada. They can only waive their moral rights. And so this is the first issue I wanted to flag, is how can an AI system waive its moral rights? Generally, it's a waiver, like an agreement that you have to sign. And so how does an AI system under law actually waive those rights? And so that's just one example of an issue that we're considering as well. I'm going to turn it over to Elizabeth to discuss some of the ownership issues as well that we're seeing from AI systems.
Sure. So, some of the concerns that we're sort of thinking about from an ownership perspective is if copyright protection does extend to, I think it's just, we're getting a little bit of feedback there. Maybe just go on mute there, Maya. If copyright protection does extend to AI generated work, then who actually owns the AI generated work? So, is it the actual creator of the AI system? Do we have a co-ownership issue? Do we have a co-author who's also a co-owner? So these are, some of the issues that we're thinking about when we think about IP ownership, which is likely to be fundamental to your business and to your organization. Is you always, sort of want to ensure that IP has actually vested with, whom it should be vested with. So whether that is the inventor or that's the author or your particular organization, is there a situation now where we have co-ownership with an AI system? One of the things in IP law that we often sort of advise on are the big complexity around co-ownership and what each co-owner can do with that particular intellectual property. And that actually changes from jurisdiction to jurisdiction. So for example, patents in Canada and what you can do as a co-owner under the Patent Act in Canada is different than in the US. So we definitely have some, fundamental issues that we're starting to think about, and our clients are asking us about, that we don't necessarily have an answer to right now, but is really something for you to think about, if you're working with generative AI, and that's really, a major part of the literary works or inventions that you're working on. is this co-ownership issue. Even if an AI system can be a copyright author, is an applicant entitled to own these AI works? Something else we're thinking about, and how can an AI system assign or license its copyright? So if we actually have an AI system that is deemed to be the owner, the author and the owner of the work, how does an AI system then commercialize that copyright? Can an AI system license it? Can an AI system assign it? We know in copyright, in order for a copyrightable work to be assignable, it must be in writing. How does an AI system go about assigning or otherwise licensing that sort of ownership interest? So these are, again, issues that are not resolved, but they're issues that are top of mind for us, especially as we're thinking about commercialization of these works, and is something that we're keeping a keen eye on around the world as far as what other jurisdictions are doing. As in this case, we don't have a situation yet, I believe, where we've had an AI system that is deemed to be the author and owner of the particular copyright. But I imagine that the next step after we talk about and get sort of more thought around who is the author and whether an AI system could be a co-author, for example. Now, how do we deal with the issue of ownership?
Another very interesting issue, we help clients navigate risk. And so, of course, one risk to consider is infringement risk. And so does training an AI system using copyright works, does that amount to a reproduction of the work? As I mentioned, as a copyright owner, you get a bundle of different rights that you can permit others to do. But if you don't permit somebody to do something with your work, it's an infringement of your rights and you're entitled to damages. And so training is a tricky issue, because is there a reproduction in the training process of the work? It really depends on how the system is being trained. It depends on what part of the work is being used or how it's being used, and whether that is a true reproduction. There is a case in Canada where there's in the broadcasting context, they're making temporary recordings for a technology advantage of the system. And in that case, the court said, yeah, that is a reproduction, even if you're not publishing the work or using it as you would previously, or making an actual physical copy of the work, as long even that temporary copy was considered. So again, it's a very fact-based analysis in copyright. So it is, but it is a live issue, this training. And if it is an infringement of copyright in Canada, we have an exception to infringement, and we call that fair dealing. And in the US, it's called fair use. And so if you're doing a fair dealing with the work, you're actually not infringing the work. And of course, the test for fair dealing is a factor test. I think there's 6 factors that you would consider: the purpose of the dealing, the character of the dealing, the amount, like how much you're using of the dealing, alternatives to the dealing, so whether there's other ways to do it, the nature of the work, and the effect of the dealing on the work. And so again, this is a fact-based analysis. There's no clear, yes, this is a fair dealing, no, this isn't, but it's a risk-based assessment that you should factor in and consider when you're looking at that issue. Another infringement issue that we're considering is if an AI system, as we saw some examples, generated output that is very similar to another work. And maybe the work was used for training, or maybe it wasn't, maybe it just independently created it. But if it was used for training, so you had access to that work, and then a substantial portion of that work ended up in the output, then that output alone and dealing and using that output may be an infringement of somebody else's copyright in the work, depending on how similar those are. So just because an AI system output a work for you, and the AI providers agree that you get to own it, there may be a third party's work involved that they have not given permission to. And so be careful when you're using that output, because it may be an infringement. Another issue that we wanted to flag that's separate from the IP regime, but very similar to it and considered is confidential information. And so if somebody's work or somebody's confidential information is used without permission, tort law actually comes in and says, no, that's actually a misappropriation of confidential information. So if an AI system is using that confidential information without permission, there could be a tort law issue that's coming out. And we generally would consider this when we're looking at copyright, because copyright can be confidential, unlike patents where you have to publish it, and trademarks require public use. Copyright can be confidential. And so that's something else we always like to consider and flag for others.
The only
We
thing
also
I was
wanna
just going to, oh, sorry, I was just going to mention on confidential information and sorry, the only thing else I was going to mention is your confidential information. So as an organization, if your inputs are proprietary to you, it's your own confidential information, or the confidential information of your clients and customers, or development parties, you may run into an issue where you're disclosing, number one, your confidential proprietary information that you don't want it necessarily be disclosing, and who knows how that input may be saved or used again by the particular AI system. And two, there may be a breach of that confidential information from use, let's say, with any of your clients or customers, that you are disclosing it to a more public generative AI system. So just wanted to highlight that, you could face an issue yourself where you're disclosing, what are really, very valuable assets, which is the know-how and information of your organization, into generative AI systems.
No, that's an excellent point, Elizabeth. So be very mindful of how you're providing information, particularly if it's not yours and it's your customers or your clients. So we want to step back and think about other IP issues that are triggered by AI systems. And so Elizabeth, given you're our brand expert, what about logos or trademarks that are generated or output by AI systems?
So this is a very, interesting issue, and one that, again, the courts have not, determined, and CIPO really hasn't weighed in on in Canada. But if we sort of break it down and we say, okay, we give, particular prompts and maybe we use a piece of art, as we see in the Surrealist matter, and we get a logo. That logo is, at its most basic form, an artistic work. So I think we could definitely run into the same issues that we were talking about with respect to copyright, as to who is the author and who is the owner of that particular artistic work. Because logos can sort of be both protected by trademark and can also be protected by copyright. So there, I think you run into an issue where you may not, in fact, own the underlying artistic work and then move to file trademark protection. This is one of the fundamental questions that we always ask our clients before they move to file a trademark. Do you own the rights in any design or image? And if not, we're always sure to make sure to get an assignment of those rights before we move to file a trademark application, to ensure that there isn't any claim later on that, hey, in fact, that's infringing my copyright because I still own that, that artistic work. So that's, one of the first issues. If an AI generated system, if it's generating a word mark, is another issue. We know that copyright, in most cases, would not extend to sort of a title or a short, group of words. And this has been litigated in Canada with respect to book titles and things of that nature. So we know that copyright does not sort of extend in those cases. And so here, where you have a word mark, again, who would be the owner, the original owner of that particular word mark? And trademark rights, how you actually garner trademark rights is through use. And so in this case, you don't have an artistic design. You don't necessarily have a literary work because it may just be sort of a short title or even a word. And so perhaps you could file a trademark in that case and, be the original, owner of that work. I mean, this is certainly not been determined, but your trademark rights are then, grown through your actual use of that trademark in association with the goods and services for which it's authored. So I think this is an interesting issue because the treatment between a logo and a word mark might be very different, given the fact that logos at their very base are typically artistic works.
No, that's very helpful, and definitely an issue to watch. As we know, it's helpful to rely on these AI tools for some of these creative endeavors. So making sure a human's in the loop as much as possible. Similar issues come up where AI systems are generating inventions, and Elizabeth referred to Dabus earlier on, and so that same machine also created inventions, and patents were filed for those inventions around the world. And so in most countries, they've said, no, you cannot get a patent naming an AI system. In Canada, that issue is still being explored. So it's before the Canadian IP office right now. We're watching that patent application, this one in particular by Dabus, and we'll see how that results. In South Africa, it has a more of a formal system without a substantive examination. They granted it a patent in that space, but generally we're seeing around the world it's a no. But from these issues, general ownership issues come up, and these IP systems and IP frameworks, require you to consider, who is the applicant on a patent or a trademark or a copyright, and how does the AI system transfer those rights? Is the creator of the system by default that legal representative and entitled to apply for these registrations or not? What if the owner is different than the creator? Or what if a user, another third party comes in, uses a system, is involved in the creation process, and that system or that user is different than the system's creator or owner? We don't know any of these answers, but these are definitely questions to explore, and they're open questions, and these are just a sample of some of the issues. And one final point we'll just make is that, AI systems are complex. They involve more than just computer code. They involve, algorithms more generally, or models and data, and it's unclear really what type of IP right will protect them. Generally, you can overlay different types of IP rights, including designs, which we haven't really got into, but of course, a design can be output by a system as well. And so, of course, pausing and making sure you think about your IP strategy more generally when you're looking at new AI systems, whether you're building them or using them. And Elizabeth, do you have any final points at all on the IP framework?
I don't think so. I think I saw here that there's a number of questions that's in the chat already. So I don't know if we want to, Jen, if you wanted us to just start going through those questions?
And before you do, though, there was just a couple just to kind of do a little wraparound on what you guys have both covered. So thank you very much for that. We can do a little bit of rapid fire in this last little bit. Is kind of first putting to you both to what are you seeing sort of on the ethical implications of using copyrighted material to sort of train AI, and this sort of informs a lot of what's happening in the space.
Well, I think for some of the ethical issues is, if you're doing something that's illegal, that's generally unethical. And also in the patent world and most of the IP systems and registration processes, you're required to sign declarations saying, this is mine, this is my original work. And so again, if you're misleading those offices, there's an ethical issue raised in that regard as well.
And the other, sort of ethical issue, and maybe it's more sort of legal and policy, but many organizations and post-secondary institutions and other organizations have policy around creation and things of that nature. And how does the use of, what are those policies around the use of generative AI tools? How does that work and dovetail with what you're doing and how you're using those tools? So there's ethical considerations around that as well, that you would need to ensure that, whatever you're doing within your organization, is not prohibited by your organization as far as their policies. But I think another issue is that many organizations, those policies are just in their infancy. And so, there may not be a lot of guidance as far as how your organization intends to use these tools, the inputs, and how the outputs might be used.
You've sort of segued into another sort of piece that we've touched upon here, and I think also is top of mind for many in our audience today is, what are some of those measures that organizations can take to ensure compliance with copyright laws when using AI, and wanting to find that balance of, having folks to play around and experiment with this, but measures that they can do.
I think education is generally a first one we say, is educating the team. If you're using, if you have a number of different people using these tools, then you might need sort of a workplace-wide training and education and explaining, the shortcomings of some of these issues, or the shortcomings of copyright if you don't have a human in the loop or what have you. I think it's also important to look at each AI tool individually and looking at those terms of use, and that compliance with those terms of use will be required. And there's not just one standard contract that applies to all of those systems, and making sure that you're looking at that AI tool provider and making sure that they're making promises that they're complying with laws as well, I think are some of those tips that we would give. Elizabeth, do you have anything else to add?
Yeah, I think, everyone that's here, I think today, we're getting a lot of good questions. I see through the question and answer chat, and it's also around that input, right? So if I'm using, one of them is, the building code, for example, if I'm using that as an input, I think it's incumbent on everyone that's here today to raise it with your organization to say, do we have the right to use what we're using as far as what we're using for training or for input? Do we have the proper licenses in place? And, number one, or two, can we rely on that fair dealing exception? How are we using it? Are we using it for research purposes, for educational purposes? Are we using only the portions that we need? Is there any alternatives to that? So I think that it's incumbent on everyone that's here, now that you sort of have the fundamental, that you really can have a copyright infringement issue with one, what you're training your model with, two, what you're inputting, and three, your output, right? So there's sort of three areas where you really could have an issue of copyright infringement. So it's important for everyone here to raise that with your organization. There's lots of, sort of guidance out there. We certainly want to provide guidance to this organization and help to provide some tools around, what are some good basics to be thinking about and questions that your organization needs to be asking itself around, what it's using to train those tools and its inputs and outputs.
Thank you both. And one sort of piece around that is outside of the organizational piece. Somebody has asked, what if the work is done by individuals that aren't attached to any organization? Are there any other sort of considerations you wanted to share?
So, sorry, go ahead, Maya.
Oh, sorry. No, go ahead, Elizabeth.
No, I was just going to say, I think that question came up in the fundamentals around copyright, and then Maya, I'll let you jump in. Where an individual is creating, something that would be protected by copyright, they would be the original author and the owner. And I was just sort of giving those two exceptions. So, for example, if you're not connected with an organization where your IP rights are assigned, for example, on an employment or contract basis, then you would be the original owner. So, there it's incumbent on you to really be thinking about all of these issues that we've raised about, is it, co-authored by generative AI? Can the AI system be a co-owner, for example? But you as the, author of any work, if you're not connected with an organization, you are also the owner of that copyright.
And an individual could also infringe the copyright of a third party. It's not a business only, activity. So a human individual can also infringe. So as, Elizabeth highlighted, it could be the input. You could be putting somebody else's work into a system. The output of the work, and you use something with that, is taking substantial portions of somebody's work. Or if you're training the system some other way using third-party work, you could still be liable even as an individual.
And so to that, if a copyright protected item or items are used to train a generative model, how would someone claiming that infringement be able to prove that it was used or used substantially?
Well, we're seeing some examples of that. For example, in the image space, an image owner might put a watermark identifying their entity name. And then the output may include a distorted version of that watermark. So you can say, hey, look, I see a portion of my watermark that's suggesting that you're using my work as a training, or the output may be so similar to the input that it gives, a sound line of reasoning that, yes, this actually does embody some of my work, particularly if it's very original and unique. It would be a very high coincidence that that output would just be, automatically generated without any of that. So looking for pieces of that input or those training data sets would be one way you could prove that.
And with, the test really wouldn't be very different, when we're just looking at copyright infringement more generally. I think one of the questions was around, well, what is, a substantial portion? And that, has sort of, it's a fact-based determination on what is a substantial portion, but certainly, where it could even be in an output that you sort of have every other word is different, but really that's still a substantial portion, even if you're not sort of lifting, paragraphs of text, let's say, for example, that could still be determined to be a substantial portion. And it's really a fact-based determination. And there's a lot of case law around this, depending on what kind of work it is. But it really would be the same analysis that we would do for copyright infringement more generally with generative AI as we do for, copyright infringement for any, sort of manual work, if you will.
And if you look at, some of the things that are now coming up around Canada, and if we do finalize our decision in AI and it's determined that AI works cannot be copyright protected, you touched upon a little bit of this. It depends, I think, that those same works could still be protected in other countries that allow for that. Are there sort of considerations as all of this is rapidly changing that folks should be mindful of if they're looking at that, depending on which way Canada goes?
Mm-hmm. Yeah, no, absolutely. Be mindful, as I mentioned, that copyright law varies from country to country. So just because Canada says one position, even if they're part of international treaties, that international treaty doesn't necessarily require all nuances of the law to be the same. So if there is a treaty that's focused solely on this and everybody's solely on generative AI or AI copyright issues, then maybe that will be something to consider. But just because one country says yes or no doesn't mean all other countries or the same law would apply.
Wonderful. Do you envision a moment where the AI, the platforms themselves, the ChatGPTs, will be able to claim rights to the content that the AI system creates?
Yeah, I think this is a great question because it does highlight contracts that come up, right? And so in addition to the IP system that we're seeing, Jen, if you're an AI tool provider, you can say, regardless of whether IP rights fall, this is my data. And you can say, vis-a-vis you and me, I own it, Maya, not you, even if you put the input in. And so I can sign a contract and say, fine, I want to use your system anyways, Jen, and agree to that. And so really just checking those terms of use, and that those terms of use can generally set out some rights along that. Elizabeth, anything else to add?
Yeah, no, I think that's exactly right. I mean, it is going to come down to what are the terms of use of the particular system. And, perhaps it will be that, the system is a co-owner, the system is the owner, and they license the rights back to you. I mean, there's a lot of sort of complexity here, and it may even determine how can you use the output. So you can use it for these purposes, but not for these purposes. So let's say you can use it for non-commercial purposes, or you can only use it for educational purposes. So, not only is there an ownership issue, there could also be a use issue. How can you actually use that output? So it's very important as we move forward. And I expect that this is what we're going to start to see is, what do those systems determine? Who is the owner and how can it be used?
Wonderful. Thank you. I know the last sort of couple of questions we've touched upon sort of in various ways. So before we end off today, just wanted to ask you both, what's a key takeaway that you'd like to leave the audience with?
Keep a human in the loop, exercising skill and judgment if you want to claim ownership of these outputs.
Yeah, no, exactly. And I think Make sure that your organizations have policies around how these tools can be used. What are you using to train? What are the inputs and what are the outputs? Do you have proper licenses or consent to use that? And if not, do you properly fit under the fair dealing exceptions? I think is really critical from a risk perspective and risk mitigation perspective from a copyright infringement perspective.
Thank you both. As I hand off to Zane to close us out, this has been a fascinating discussion in a space that is very rapidly evolving. So thank you very much for carving out time out of your day to share with us your insights. And I know there'll be some resources as well. We'll share with the audience sort of with some of the things we've touched upon. So Zane, I hand it over to you. Thank you both again so much.
Thanks, Jen. Thank you once again for joining the webinar today, hosted by Digital and our wonderful Director of IP, Jen. All those attending today will receive a follow-up email in the next couple of days with any resources discussed throughout this session, including the insightful presentation from our panelists. That is it from us at Digital, and we'll see you at our next webinar session. Goodbye.